our introductions. Good morning, and thank you for joining us today for our workshop called Alternatives to Conservatorship. My name is Victoria Berry. I'm with the Family Focus Resource Center, and we have representatives from Disability Rights of California with us today, including Senior Attorney Maria Iriarte, who's going to be our main presenter on the topic of alternatives to conservatorship. So welcome. Thank you, Maria.
Thank you.
Thank you. Before we officially get started, I'd just like to do a quick overview of agency in case you're not familiar with who we are. So my name is Raymond. I am an advocate with Disability Rights California, and I also have another advocate with us today, Jessie Lara, who's will be monitoring the chat. So before we get started, Disability Rights California, we are a statewide nonprofit, and we provide free legal services to people with disabilities with any disability-related issues. We have attorneys and advocates statewide that can help with a variety of issues from access or discrimination with housing, with transportation, with education, which includes special ed and higher ed. We can also help with public health benefits such as Medi-Cal, in-home supportive services, Social Security overpayment issue that relates to work. Those are some examples of the issues we can help. That's not a full list. We also have different programs in our agency, such as our Office of Client Rights Advocacy, or OCRA. They specialize in helping clients of the regional center, and our Client Assistance Program, or CAP. They specialize in helping clients of the Department of Rehabilitation. So before we get started, I'd just like to thank Victoria again for having us here today. And for those of you who might have joined a little later, we will hold questions and answers till the end of the presentation when the recording is stopped. This way you can ask your questions freely. And during the question and answer portion, please also keep it on topic. Today's topic is alternatives to conservatorship. If you have a more specific questions you'd like to add your personal situation, please feel free to reach out to us, to the RC. Our phone number is in the chat, is 800-776-5746. Once again, we are a nonprofit, so all our services are free. And our phone lines are open Mondays, Tuesdays, Thursdays, and Fridays from 9 a.m. to 3 p.m. If you call us outside those hours, you can leave us a message and our advocates will get back in touch with you. Everything you see today, anything that's shared in the chat, along with the PowerPoint presentation you're seeing on screen, will be shared with you after the presentation. So without further ado, Maria, please take it away.
Great. Am I talking? Hold on. Can you hear me?
Yes, we hear you.
Okay, great. I wasn't sure if I was on mute or not. Hi, good morning, everyone. So today we are going to be speaking about alternatives to conservatorship. The information I give you today is good today. It may change tomorrow. So when you're looking at this information down the line, make sure you're aware of that. In order for me to talk about alternatives, I do have to talk a little bit about conservatorships. This is not a training on conservatorships or how to do it. But, the focus is alternatives to conservatorship. And then we're going to look at the alternatives. And the alternatives include supported decision-making in the areas of healthcare, education, finances, and we're also going to be looking at other alternatives in these areas. We're also going to be talking a little bit about capacity too, and what that means and how we should be looking at capacity. So I guess these questions really are, or what's here on this page is really about, basically what if others made decisions for you about who you should be hanging out with, about, your health, about how you spend your money, about maybe the choices that you made weren't the best choices and they use that against you in saying you don't have capacity. All of these questions are things that touch conservatorship. A conservatorship is it's obtained through a court proceeding. A judge at a certain period of time will have a hearing and will have hearing before him or her have evidence. And then that judge, based on the evidence, will decide whether to appoint a conservator. The conservator is the person who makes the decisions. The conservatee is the person whose rights are going to be taken away. When I call a full conservatorship is when someone files a petition for conservatorship of the person and of the finances. So it takes over their financial decision making over the person, meaning do they go to school or not? Who do they hang out with? Where do they live? What they eat, what they wear, those kinds of things. So that's a full conservatorship. Sometimes people go in and just seek a conservatorship of the estate, meaning the finances, or sometimes just the person, but most of the time it's both things. And so a judge needs to be convinced that the person who's being conserved doesn't have the capacity to make these kinds of decisions. Why do parents think about getting a conservatorship, especially when their child is about to turn 18? Well, because that's what they're being told to do by the school, by healthcare professionals. And yes, they should rightly be concerned about how are they going to help their adult child access healthcare, prevent financial abuse, or link their adult child to services that are available. Because at the time anyone turns 18, they become an adult. And unless someone has a piece of paper that authorizes that person to make those decisions, it won't happen. That person won't be able to do that. So, what are those pieces of paper? What are those tools? And that's what we're going to be talking about. One of them is a conservatorship, but, it doesn't always need to happen. And conservatorship is never needed just because you have a diagnosis of some sort, of some disability, because you need help, or because it's the way that it's always been. And there's an illusion of conservatorship. So when people get a conservatorship over someone else, they think that it's the only way to protect their children or loved ones. But there's no extra protection with a conservatorship against financial scams, physical or sexual abuse, police arrest, and jury convictions. It could happen even with a conservatorship. Other risks of a conservatorship, it's usually permanent, very difficult to reverse, could be expensive to reverse too, because at some point when the judge decided that yes, this person should be conserved, there was evidence to show that this person didn't have capacity. Court checkups, usually by an investigator, are not as often as they should be. And that could lead to problems, right? Because this investigator is not there to make sure that the conservatee is happy with what's going on or what concerns there may be. And when the conservators die, here it says the parents, but whoever the conservators are, and they could be more than one, when the last one dies off, the court can decide that it doesn't need to respect the chain of succession. Maybe there were others in line, or maybe the court decides that no, this person should no longer be the conservator for this or that reason. Of course, there needs to be valid reasons, but the court can change that. The court can even appoint professional conservators. Just because the court approves the conservatorship doesn't mean that that's the end of you and the court. The court will always be involved when there's a conservatorship. Also, there is a form that conservatees receive that talks about the rights that they have. And I'm going to go ahead and show you this form. So this is a form called Notice of Conservatee Rights. And it says here, when a person becomes a conservatee, he or she does not necessarily lose the right to take part in important decisions. And the conservatee keeps the right to be represented by an attorney, asks the judge to replace the conservator, asks the judge to end the conservatorship, to make or change his or her will, to direct or control salary and allowances. Now, unless the court takes this away, these next rights, the conservatee keeps the right. So the right to receive personal mail, vote, marry, receive visits from family and friends, make medical decisions, enter into transaction, engage in activities. So really, the rights that are taken away are the rights that are outlined in the letters of conservatorship, and not every time everything is taken away. So, so this is an important notice that's given to conservatees, and you've got it here in the presentation. Here's the link. Of course, sometimes a conservatorship may be necessary. Let's say in an emergency situation, the person is incapacitated, mainly doesn't have capacity to give consent to treatment, and the person didn't leave like an advanced healthcare directive, and there's no one in the person's life to make to provide consent because there's no power of attorney or whatever else. A conservatorship may be necessary, and there's something called a temporary conservatorship. So that might be the appropriate thing in this situation, and then it ends when the person regains capacity. And sometimes conservatorships are necessary to help people make critical decisions who never have been given supports to make and communicate their own decisions. So sometimes, you know, because when we're going to talk about the alternatives to conservatorship, almost all of them require some form of capacity to sign documents, right? Giving someone else the right to act or receive information. You know, capacity is not, the judge in a conservatorship is going to need to find lack of capacity. So we've talked about all of this. The one thing here is that conservatorships can change relationships. Like if my mom becomes my conservator, and I'm not happy with the decision she's making, I may get angry at her and not like her a lot, you know, and act up perhaps maybe. And that can change relationships. So the other options that we're going to talk about here are the ones that are listed here. And I want you to look at these options as tools in your tool chest. You could, maybe you need just a, you know, an advanced healthcare directive for medical decisions, or for education, all you have to do, all that needs to happen is that a form needs to be filled out. If the only thing I have in the world are the SSI payments that I receive, well, we don't need anything. If my mom becomes my rep pay, she takes control over my money and is audited by the Social Security Administration every year. So no need for anything. But, you know, these are the tools that are available to you, and the supported decision making is available throughout all of these, whether they be financial decisions, educational decisions, healthcare decisions. The person with a disability can have his or her circle of support, so that you know, so that the person with a disability can ultimately make decisions based on, you know, whatever the circle of support has been tasked to do. So choosing the best decision-making strategy, when you're thinking about the tools that you need here, think about what kinds of decisions need to be made, how much risk is involved, how hard would it be to undo the decision, and has this person made a decision like this before? The real question to ask is, what's the least restrictive support that might work, right? Without talking or thinking about, the most restrictive would be a full conservatorship. So this is the first alternatives to a full conservatorship, is called a limited conservatorship. It is only available to regional center consumers. So if I have a mental health disability and my mom files a petition for limited conservatorship in the Superior Court's probate division, this is where it happens, it's going to be kicked out because I don't have the requisite disability to be able to, for my mom to be able to obtain a limited conservatorship. And when she does file one, and let's say that I am a regional center consumer, she can check off all of these rights because these are the only rights that can be taken away in a limited conservatorship, up to 7. So she may check off all 7 of them. Will she be able to get them? Depends on what evidence the judge has before him or her when that decision is going to be made. It may be that the judge decides that the only right that should be taken away from me is the right to sign contracts, and that'll be it. There are things that the conservator cannot do, which is control for example, in my mom's case, she can't control my salary or my allowance. She can't approve harmful medical treatments, force me to undergo drug treatment, sterilize me, put me in an institution, make me undergo electric shock treatment or psychotherapy. Cannot do. Once a limited conservatorship is filed, and this applies also to a full conservatorship, an investigator is going to be assigned. That investigator is going to interview me, explain the process, determine if I'm in a position to attend the hearing, whether I oppose the conservatorship, whether I oppose my mom as being my conservator, do I prefer someone else? The investigator will also interview others, family, friends, determine if indeed a limited conservatorship is needed and whether my mom is a suitable conservator. Now, inevitably I get asked this question, and it's typically from parents whose children are going to turn 18 pretty soon. And the question is, how soon before they turn 18 should I file, limited conservatorship petition? And I have to say, I don't know, for 2 reasons. The first one is there are Superior Court probate divisions that are busier than others. So what you would need to do is call the probate division of your Superior Court, your local Superior Court, and find out how far ahead they've booked hearings. If the clerk says to you, oh, we've already booked hearings for the next 6 months, and your child is going to turn 18 in 3, well, go ahead and file the papers because nothing's going to happen in 3 months. It's going to take longer than that to even get a hearing. So by that time, your child is 18. But the other thing that definitely we do not know, you can't talk to anyone about this, is that it may take the investigator time to complete the investigation. When I was giving a training on this, someone from the audience indicated to us that the investigator took 8 months to complete the investigation. The investigator spoke to everyone under the sun, and it took that long. Other people have indicated that it took only 2 or 3 months to go through the process. So the big unknown is how long it's going to take the investigator to prepare a report, do all the investigation, interview, and then prepare a report for the court. The regional center will also prepare a report. That report has to be filed at least 5 days before the hearing. It's confidential. The parties to the hearing get a copy, but it's not a public document. And that report's going to talk about the nature and degree of my disability, what type of assistance I need, my mental, social well-being, physical condition, and recommendations on the rights requested in the petition. I'll also be, by the way, I could be assigned an attorney. Most likely I'll be assigned an attorney, and that attorney is there to represent me. And so that attorney will be in contact with the court, could appear at the hearing, submit documents at the hearing. That's another player in all of this. Because I'm a regional center consumer, I can go to my client's rights advocate. The Office of Client Rights is our sister organization. For every regional center, there's a client's rights advocate and an assistance client's rights advocate. They are not employees of the regional center. They're there to advocate for regional center consumers. So I might go to my client's rights advocate and say, hey, this is what's happening. And that person can talk to me about what's happening, talk about alternatives, talk to my attorney, the investigator, might even, appear at the hearing on my behalf. Who knows? If you don't know who your client's rights advocate is, you can call the 800 number, but you can also go Google OCRA and you'll find that information on their website. So a judge has to determine by clear and convincing evidence that the conservatorship is necessary to promote and protect the person's well-being. Clear and convincing is more than by preponderance. By preponderance, we usually define that as above 50%, but clear and convincing is not beyond a reasonable doubt, which is used in criminal court, but it's up there. So, because they're important rights that are being taken away. But what is the goal here? The goal here is to keep people as independent as possible and let them shape their own lives. That's called self-determination. That's why we do these trainings, because full conservatorships are not always necessary. Self-determination. Here's some articles about self-determination and how people who have been allowed greater freedom feel that it gives them more independence, freedom to decide what they want to do. It gives them more independence. They feel more integrated in their communities and are healthier and better able to recognize and resist abuse. So self-determination is really important. So let's talk. So we've talked about limited conservatorship as an alternative to full conservatorship. Now let's talk about supported decision-making, because the supported decision-making can be used throughout as a tool as a person with a disability, I can decide that I want people to be my circle of support. And these people can be my circle of support for any questions I may have. They may even advocate for me. They may go to my medical appointments to help me. They can help me in many ways. Or I may decide that I want for supported decision-making to help me make decisions. I want different groups of people for different situations. It depends on what I want, right? Some of you parents may be saying, well, I support my child in all decisions and I try to make the best decision possible, but it's different. You're making those decisions. Here, your child with a disability is making the decisions based on support that he or she is receiving from the circle of support. So, and supported decision-making is an alternative to conservatorship that has to be considered. And that came into being with Assembly Bill 1663, which says, among other things, that starting January of 2023, petitions for conservatorship, whether they be limited or full conservatorships, have to include alternatives to conservatorship that were tried, if any, and why they were inappropriate. In fact, when there's within the petition, there's a section that asks the petitioner what did you consider alternatives to conservatorship, and if and why do those not work? So what alternatives do you consider and why are those not working before they file for before they agree to a conservatorship or limited conservatorship? So you have to answer those questions as to why these alternatives, including supported decision making, is not going to help the person make informed decisions. And we saw the form that conservatives get about their rights that they retain. And the bill also allows that a conservatorship to be terminated without a hearing if both the conservatee and the conservator agree that the conservatorship should be terminated. So we've talked about limited conservatorship. We've talked about supported decision-making. I want to step aside for a moment and just talk a little bit about capacity, because when we talk about capacity, we're talking about legal capacity, which means the person's ability to make decisions and to be responsible for those decisions. Capacity is not an all or nothing thing. It's not based solely on IQ or diagnosis, because some people may have capacity to make some decisions and not others, make decisions sometimes and not other times, and make decisions if they get help understanding the decision to be made. That's supported decision making. So rather than thinking, what could this person do all alone on a desert island, we should be thinking, what could this person achieve with help and guidance from friends, family, professionals, and with technology, education, patience, and practice? Supported decision making, your circle of support. So everyone seeks help with difficult decisions. I do. People without disabilities are encouraged to seek help. So why can't people with disabilities do the same? So we're going to talk about supported decision-making in the areas of financial decisions, educational decisions, and healthcare decisions. And we're also going to talk about other tools within these three areas. So when we're talking about healthcare, what could your circle of support help you with? To understand the information you're receiving from your healthcare providers, to communicate with providers if necessary, help you manage your daily needs. They can help you access healthcare. They can help you understand medical information and help you make medical decisions, give you the risks and benefits, maybe a procedure that some healthcare providers has been recommended. But there are other forms of other ways of other tools for healthcare. The next few slides really talk about informed consent and how someone in your circle or your circle of support can help explain what the doctor's doing, help you understand what the doctor's saying, and help you communicate what you want to have happen. Another alternative for healthcare is the power of attorney for healthcare. In California, it's also known as the medical power of attorney. It's a document that gives someone else the right to make a decision. So let's, for example, I fill out a power of attorney indicating that my mom is going to have power of attorney to make financial decisions for me or healthcare decisions for me. And so that's fine as long as I have capacity to understand what I signed. I have to understand the effect, the benefits and the risk of what I signed. I don't have to understand the fancy words. I just need to understand that by signing this document, I'm giving my mom the right to make, for example, healthcare decisions about me. I'm not going to be able to make those decisions, but she better understands everything, and she would always look out for my best interest. So she would probably be the best one to do so. And so the risk is I can't make those decisions. I also need to understand that I can always take that power of attorney away from my mom. and give it to someone else. Or maybe I can decide, hey, you know what? I don't need anyone to make healthcare decisions for me. I'm not going to give the power of attorney to anyone. But depending on what type of power of attorney it is, sometimes you need to have it notarized. That's especially true with real estate transactions, or it could be witnessed by two uninterested witnesses. The power of attorney can be general, meaning it covers all the areas, or limited, it only covers an area. And it could be durable, meaning it comes into effect at the time it's signed, or springing, it comes into effect down the line when something happens. So an advanced healthcare directive is a form of a springing power of attorney. The other way to get information is that my mom can call my healthcare provider and say, I need information on Maria. And they're going to say, well, unless we have a document from you that gives you the right to get this information, we can't release it. And we have Maria can sign a HIPAA form so that you can be part of, her healthcare or get this information. So I would need to fill out, usually healthcare providers have their own HIPAA forms. And so my mom would ask for one to be mailed, and we would go over it, and I would sign it, giving my mom access to my medical information. She can even be with me present while I'm at my doctor's office. There's also something called the Advanced Healthcare Directive that gives. Now, there is a healthcare directive here in California that when you sign it, you either make it effective immediately, or it acts more like an advanced healthcare directive where you check off, I don't want it to, it will only become effective when I no longer have capacity. So that would be more of an advanced healthcare directive. Here are some examples of that. So let's say that I signed an advanced healthcare directive. I had capacity. I knew what I was doing. That my mom would make healthcare decisions should I lose capacity. And let's say that I'm involved in an auto accident. I'm taken to the hospital. I'm in a coma. So through my advanced healthcare directive, my mom would be able to make decisions as to whether or not they should pull the plug, because the doctors are saying, hey, she's not going to come back from this. We need to make that decision. So she would, and in my advanced healthcare directive, I would actually instruct my mom on what my desires are. I don't want to be artificially maintained. So she would know that she would need to pull the plug on me. So advanced healthcare directives are good for everyone. I have one. I actually went to an estate planning attorney. Well, my husband and I did. And I have an advanced healthcare directive that's about 18 pages long. And the kinds of questions that I needed to answer were things I had never thought of. And I can't think of them right now, but it was a lot more than, what does she want to do about pulling the plug or not? Lots of things to consider. So well worth having an advanced healthcare directive. When we're talking about financial decisions, supported decision-making is there. With my circle of support, they can help me understand financial information, communicate with my financial institutions, help me manage money. But I want to spend it on something. Should I spend it on something? I could go to my circle of support and talk about it and hear the pros and cons of spending my money on that thing and decide whether I want to do that or not. Other ways to help with financial decisions is set up automatic bill pays from a primary account so that happens automatically, no worries. The other thing that we can do, my mom and I, we can open up a joint bank account. She has equal access as I do to that account, easy. The only caveat is that if I'm receiving public benefits, especially SSI or maybe other benefits, my mom shouldn't be putting any of her money into that account. It's strictly basically to be able to help me manage my money, right? So she would have access to that joint bank account. Once you turn as a consumer of the regional center, once you turn 18, you can ask for a service called independent living services. And those services will teach me how to manage my money. They also teach me how to cook and clean and take care of myself, access the community, access transportation. Supported living is, let's say I want to live independently from my mom. I want to live in my own place or with roommates. Well, there's a whole host of services that the regional center can provide to allow me to live independently. There's a lot more to this, and we have a manual online called The Rights Under the Lanterman Act, and we have a chapter that talks about these services for consumers to become more independent. If the only thing, and I mentioned this before, that I have is my Social Security payment, my mom could become my representative payee. Why would we need a power of attorney? Why would we need anything else if it's this easy, right? But we can also have a power of attorney if that's necessary. We can open up a special needs trust, and my mom can be the trustee of that trust, and she can manage the money in that trust for my benefit. I can even open up, if I qualify for an ABLE account here in California, it's a CalABLE account, and we're putting the links to this program in our chat. Through the when I sign up for the CalABLE program, actually assign my mother as the authorized legal representative. So she is the only one who will have access to that account, and she's the one who will manage that account. So there are many ways to do this. Just depends on what the needs are. Let's talk about supported decision-making in education. Many children with disabilities are not given the ability to make choices, so they can't learn from their mistakes when they make choices. Often schools promote conservatorship as the only option, not true. And why not practice decision making from the earliest age? And how does that look? You can invite your child to attend IEP meetings in early grades as much as possible, as long as it's possible. And in the IEPs, you should include goals that are ambitious, that promote student involvement, that target self-determination, self-advocacy, and problem solving. But it's pretty easy here in California through the education code. Let's say that I turned 18 today, and next week there's an IEP meeting, and we go to that IEP meeting, and the IEP team says to my mom, Maria is now an adult. You cannot be here unless you have, something that in writing that says that you have the right to be here. And here it is. In our manual in Appendix P, we have a sample form that I could sign and put my mom's name on that form, indicating that I want her to continue to be the person who makes educational decisions for me upon turning 18. And so it's easy as that. I don't need a power of attorney. I don't need anything else. So there are 2 sample forms here that you can use. Other ways to make educational decisions: power of attorney, limited conservatorship. I've given you a number of resources here. If you want to know more about supported decision-making, there's DDS has information on supported decision-making on their website. Disability Voices United has a lot of good information on supported decision-making. The self-help resources. So superior courts before COVID, many of them had self-help resources where, among other things, they would help people understand conservatorship, limited conservatorships, alternatives. Some courts even had like a clinic that you could go to understand what forms you needed to file with the court and understand the process. Well, COVID hit, everything closed. And I don't know if the self-help clinics are up and running in your Superior Court. What you can do is call and find out. Hey, is there a self-help resource center or clinic for limited conservatorships? And you can find out more about what's going on in your local Superior Court. But if you go on to this website, California Courts, there's information on conservatorships, limited conservatorships, alternatives to conservatorships. There's a lot of information there and other resources here that you can look at. So we have come to the end of the presentation. And so we are going to go ahead and stop the recording. And we are going to go ahead and take any questions or comments. If any of you have gone through the process of a limited conservatorship or using some of these alternatives to conservatorship, happy to hear, how it's gone for you or how it